And reactions have continued to trail the Supreme Court's decision on the President's emergency powers under Section 305 of the 1999 Constitution of the Federal Republic of Nigeria as amended in the light of the emergency rule that was imposed on Rivers State by President Bola Tinubu. While some commentators, including some lawyers, believe that the Supreme Court's decision may likely enthrone an authoritarian presidency, some others argued that the Apex Court's decision is the correct interpretation of the provisions of the law. All right, joining me tonight now to discuss the legal and political implications of the judgment, Dr. Sam Amadi, the Director, Abuja School of Social and Political Thought and a RISE analyst. Very warm welcome to Newsnight.
Thank you, Chris. Thank you for having me.
Can be the furore there, the Apex Court is, is the highest decision-making or given vent to judgments from lower courts and the rest. It has interpreted the Constitution in the best manner it deems fit, without political considerations.
Well, sure. I mean, in a way, that's the final court, and for that reason, actually, whatever the court decides feeds back into political discourse, because the court, like the leading American political scientist, Robert Dahl, he says the Supreme Court is political institution, and he tries to define what it means. He says because it deals with political settlement. The idea of true branch of people don't know that the court, what the court does is political, to the extent that a dispute is framed. Some are handled at the level of the executive branch, so some are handled at the level of the legislature. For example, the legislature has an zone of no interference. They make the law. You can't stop them. You can't input your own knowledge into that law, but you can go back and judicial review. So the executive has area of no interference. The president has to hire and fire. You don't necessarily interfere on who he hires. But then the court also has its own zone. So when the court speaks, it creates political impact. First, I think that the court, three things. One is that the court did not decide this matter when it had recency and value, when it's been challenged. Of course, the court manages its docket as it likes, so it decides not to hear it then and hear it now. Second, the court dismissed the case, or rather struck it out in limine, like we say, on the basis of want of jurisdiction. And the basic argument is that the PDP states didn't quite show enough legal connection to the dispute in terms of harms or in terms of rights they lose, because the fact that the Supreme Court, the Constitution says that the states can sue the federal government at the first instance, the Supreme Court, doesn't necessarily confer standing if you don't show connection. And so they say the Rivers State Governor, Attorney General, should have been the right person, or at least show something that connects or shows. But again, that's where the suit was struck. But the things that the Supreme Court said, justices, whether obiter, meaning not really determinative of the issue, carries weight, because they shape policy. That's the point. So if they say the president can do X, Y, Z, even though it does not constitute precedent, it kind of defines participation of presidential power and how they manage. So many people who criticize that judgment, or those by the way statements which don't constitute, precedent, are worried that they create a precedent, if you like, and shape constitutional discourse to now authorize presidents to do everything they want.
Does that mean authoritarianism?
Well, if the president can dismantle constitutional governance in the states on a ruse, because the idea of if it appears to him is subjective. I mean, the courts will concede that even if I don't feel that there was any likelihood of breakdown, you can feel there is. So factually, you can't predict. The president has a latitude of leeway to say, it seems to me there will be a likelihood. By the way, we've seen this in 1956 at the Western region crisis, where the law seemingly,
the wild west,
where it says if it seems to the premier that somebody it could declare a state of emergency. So that the court says There's an element of subjectivity here. But the bigger problem is that the court, in my view, the only error I see in my own reasoning is that when they say, they actually say the president cannot do anything or whatever he likes. There's a limit to the presidential power in the emergency. But they also suggested that he could dismantle constituted state government. And the problem is that if they balance Section 305 with the fact that the Constitution has guaranteed a democratic governance for the federation, that's why coup plotting is unconstitutional, guaranteed for the state and local government. Why the same Supreme Court said that the governors cannot, under the condition, dismantle elected democracy. So they would have argued that the president has spectrum, plenary power to federalize the state if there's a crisis. For example, he can trump the state judgment. If the governor or House of Assembly makes a law, the federal government can trump it. And that's the idea of, if you look at the US, when Trump claims emergency power, what he claims is the power to override state decision making, whether at the level of legislature or executive, not to override democracy by suspending or uprooting any state elected government. So it's possible the court can concede that under some emergency power, the president can, for example, make law directly, prescribe, create a curfew.
Based on the threat level here.
He perceives. So you can imagine a governor still being there, House of Assembly, but the president federalizes intervention and says, I override this. Because of emergency, this crisis, this threat, curfew by 6 to 4. Those are arguable, legitimate use of executive power in emergency. Yeah. But I doubt, so the Supreme Court had broadened first as a policy court to say, what would be the implication of saying the president can dismantle elected government? How does it fit in with the notion that the Constitution itself guarantees democracy? So the problem with the Supreme Court sometimes is that their reasoning may be deficient in rigorous constitutional theorizing. You see, the constitutional law is not just about Section AB. Just like my professor at Harvard, Larry Tribes, who's the doyen of American constitutional law, says, most of the decisions constitutional law in America are not specific sections in the Constitution. They are what they call the work of judicial statesmen. So they think about what does democracy require. Then they go and interpret those laws to foreground what democracy requires. So if you sit here and say a president can dismantle the state government because he feels there's a crisis or a threat, you create a possibility that any president could actually use that to settle scores, could use that to confer to himself a political advantage. So I think that there is a good reason why the public is worried. There's a good reason why there's a debate, because it was a gratuitous error. Because first, the court has said, we're not going to deal with this. You have no standing. But the typical of Supreme Court justices, they have a right to theorize and argue. But what they are saying is powerful, whether it's president or not. And so to have created this very non-rigorous, like a Desico, if you ask me, approach to important issues, what people. So for me, I would say they got the facts right, no standing, but they didn't perhaps think broader around the fact that the constitutional, most fundamental point of the Constitution is protecting democracy, entrenching it and guaranteeing it. And so no threat level, even in war, the president can declare war and still be president. And that's why if you look at subsection 2, it talks about the state governor requesting the president, the National Assembly, to even declare a state of emergency in his state. So he can still be governor. And because of the level of threat, he requests that the president declares it, because state of emergency attracts resources, attracts federal power in a special way, federal security, and federalizes. For example, you can meet the president who send the soldiers on the streets.
Well, we saw that during Jonathan's
exactly. It does not necessarily mean that the president has to suspend democracy. So I think that's the bad side of the Supreme Court reason, and it was not rigorous in my view. And so, and again, when Supreme Court speaks, it doesn't mean that they freeze debate. Their decision is final, but their logic is always contestable, refutable, because that's why it's a discourse. The Supreme Court is a political institution, as Robert Dahl, the doyen of political science, says, and it's right.
Thank you. Thank you so very much. Associate Professor of Law, Sam Amadi, and Director, Abuja School of Social and Political Thought.
Thank you for having me.
Arise Analyst. Thank you.
Thank you.